I'd like to ask that item 3 and item 4 be consent items unless any of the members would like to pull them and have them heard.
Good.
If not, those 2 items will be on consent.
I just have one question.
Sure.
I'd like to see if we could ask the CLA to determine on both of those items whether the system they're looking at for universal call system can be included in either one of those grants. The emergency, what do we call it?
Mass notification.
What?
Mass notification.
Mass notification. That's it.
Reverse 911.
Yeah.
Okay,
Yes.
okay. Anne Marie Sauer, CLA. We have worked with the, we've looked into that for this, and that's not an eligible expenditure for this. These have gone through that process, and this is not because of previous UASI funding for the fire department's earlier mass notification system. We aren't able to use these funds for that.
Either 3 or 4?
Right.
Okay, thank you.
Okay, so with that, we'll otherwise leave those items on consent. And otherwise, let's begin the meeting.
Item 1,
Yes.
this is to present verbal report relative to the status of DNA testing, backlog, and cold hits, the handling of latent prints, and other related matters.
Good morning. I'm Commander Pat Gannon from Detective Bureau of LAPD.
And I'm Greg Matheson, Director of the Los Angeles Police Department Criminalistics Laboratory.
This is our periodic, generally we were doing almost a weekly update on backlog of rape kits, and I think we've missed the last couple of weeks, and now we're back. As of July the 8th, our current backlog is at 4,168 rape kits, which is down from 4,327 the week before, a change of 159. So far this year, we've had 652 rape kits that have been booked into property, which is about what we had estimated, we run about 1,200 rape kits a year going into our property system. We average somewhere around...
a little bit of background to put it into context, particularly for me as someone who's new.
Well, back in basically October of 2008, the city controller issued an audit of sexual assault kits that had been analyzed or backlogged by the police department, and there was approximately 7,000 rape kits that had not been analyzed by the police department that were sitting in our evidence lockers. As a result of that particular audit, a number of changes were made both in the police department and in the funding of this particular issue. One is it relates to additional criminalists that were at the city council approved the hiring of 16 additional people for our SID, 10 of which were criminalists and 6 of which were not administrative staff, but staff to assist with the criminalists. In addition to funding significant amounts of money in order to outsource the greater amount of rape kits that needed to be analyzed. At that particular time, within the police department itself, the Scientific Investigation Division, which is responsible for analyzing our rape kits and outsourcing our rape kits, was under Administrative and Technical Services Bureau of the Police Department. The Chief of Police made a decision to switch that function, that responsibility for oversight of Scientific Investigation Division, to Detective Bureau. The Chief of Detectives for LAPD is Charlie Beck, and I'm the Assistant Commanding Officer of Detective Bureau. Since October, we have gone into the freezers of all of our sexual assault kits in the police department are frozen evidence. There are large freezers at both our Piper Tech facility and actually some trailers that are frozen that contain this evidence, all contained over there at Piper Tech, with a little bit at Scientific Investigation Division and a few rape kits at Parker Center. we literally did a hand count of every single piece of frozen biological evidence, sexual assault kits, whether it was related to a rape or whether it was related to a murder or any other type of offense, so that we could get a true count of what the number of sexual assault kits that were in our custody. As a result of all of that work that has been done, since that time, September, October-ish, till now, we have either outsourced or tested in-house almost 3,200, a little over 3,200 sexual assault kits as we move towards analyzing every single sexual assault kit that comes into the police department. That's the kind of a snapshot of it, and as we've come before this committee to give status updates on a regular basis as to how we're doing with that. And there's going to be I'll let Greg Matheson talk a little bit about how furloughs are going to impact SID, Scientific Investigation Division's ability to continue to work on the backlog reduction plan that we have. But essentially, we had set out to reduce or to eliminate the backlog. We average right now somewhere around 400 kits, 400 to 450 kits that are outsourced a month, plus an additional 30 to 40 that are done in-house as we continue to work towards that. Obviously, with fewer days for criminalists assigned to SID because of furloughs will impact that to a certain degree. They'll impact more the in-house, which are the fewer the ones that we do than it does the outsourcing of those particular kits. So we're still working. We had a rough draft of how that furlough is going to impact us, and by next week I should have a better idea as to how that's going to impact the overall plan.
Do you have any idea when roughly you expect that you'd be caught up?
Our original goal, the goal of this whole program, where we want to be with the number of budget requests we've made, is to completely eliminate the backlog of previously untested rape kits, and then have enough staff to be able to analyze them all basically in a timely manner from when they're collected, so that we don't have a backlog increase in the future. We were originally shooting for all of the rape kits, the backlog rape kits, to be completed by the end of this current fiscal year, by July 1st. However, that was contingent on a certain level of funding, somewhere in the total of about $5.5 million. At this point, we don't have that available to us. So at the end of this fiscal year, and along with the furloughs, we're estimating to still have about 2,000 to 2,500 left in the backlog. We do have, just along with continuing to provide a little background information, one of the misconceptions many times that occurs is when you outsource casework, it involves very little work other than sending it out and paying the bill. The reality is we currently have about 10 people doing nothing but reviewing the cases, packaging them up, sending them out, receiving them when they come back, and preparing the reports and the paperwork on that end. Once the results are back, CODIS, which is the database that allows us to search offender profiles and identify who the person is that committed the sexual assault, a private laboratory can't upload into CODIS. Only a government agency can. And by federal law, our people basically have to take ownership of that case. So when we outsource a case and it gives us a profile from the offender, one of our trained DNA analysts has to do a complete review of all the data from the outsourced laboratory before it can be uploaded and searched. So the outsourcing process, you have 10 people on the front end and sending and receiving the cases, and then anywhere from 4 to 6 DNA analysts doing the case review on the back. So our outsourcing is costing us about 14 to 16 people, something like that. So those are people that are not right now able to work on cases in-house.
And the CODIS database that he speaks of is a state and national database that houses all the DNA profiles. in there, both on case-to-case and on individuals. To kind of give you an example, we talk about analysis, but really the overall goal is to find people, is to match people to the particular crimes. So for example, the state has now 1.2 million samples in the state database. In May, for example, they had 314 hits in the month of May, 70 of which were LAPD hits. So a good percentage of the overall hits statewide were LAPD. In addition, for all of our profiles, we had 198 profiles just in-house that were uploaded into CODIS in June. So that's all of the work that's coming from the outsourced cases coming back with information, plus our in-house information that's developed, DNA profiles that are now being uploaded. And every single day, as individuals are booked into our system and booked throughout the entire state now, for almost every felony crime, there's a requirement that each of those individuals, arrestees, submit a DNA sample. So all of that information is just pouring into the state database, which has given us more and more hits as we go along. It's a tremendous tool for the police department throughout the entire state. Now our challenge is to keep up with it and to have the ability to use it as efficiently and effectively as we can. We tend to prioritize, obviously, with sexual assaults and homicides and those kind of things, but the ability for this to work on property crimes and other types of crimes, the upside to this is tremendous. It is expensive, but it's tremendous.
Thank you. Any other questions?
Actually, I'd like to bring one other issue before the committee. About 2.5 weeks ago, a U.S. Supreme Court decision, Melendez-Diaz versus Massachusetts, is going to potentially have a significant impact on our ability to get DNA cases out the door, along with many of our other forensic services. The short end of the story is that it ruled that our analysis reports are not business records. And business records being an exception to the hearsay rule, it used to be when the original analyst wasn't available, or if you used batch processing, we could have somebody go in and either testify to the whole batch process, or we could have somebody else testify to business records as to that person's results. With this new ruling, we can't do that anymore. So what's happening is every case where an analyst is retired or is on a vacation or on a furlough day or whatever it happens to be that can't go in and testify, we're being asked by the DA's office to reanalyze the case. Statewide, nobody has a clue really how much of impact this is going to have, but we already are seeing people sitting in court for extended periods of time because the DA doesn't want to be caught short without having the analyst there and present.
Does that mean if you've sent a kit to an outside contractor, you come back, you verify it, and send it on, if that original person at LAPD that verified it is gone, do we have to send the kit back out for reanalysis, or we just do it from our end only to certify the numbers?
We would just have to have somebody else in our laboratory do that review, which could be 2 to 4 hours. But I appreciate you bringing that up because this does impact the private labs too. They are going to have to send their analysts out and testify. The impact on our assembly line processes or batch processing is the decision does not identify who the analyst is. So one of our ways of increasing efficiency is to assign people a certain portion of the analysis. You may have 5, 6, 8 people working on a different part of a case in order to increase throughput. Under this, all of those people would have to go in and testify if called by the defense or if called required.
This seems almost impossible. How could...
Well, it's so new, and we're not sure yet how the impact of this is going to be felt throughout the entire country, actually. Right. But it's clear that this is going to be a challenge for us as we see it, and not just on our murders and rapes and those types of things, but something as simple as DUI cases also, where you have machines that are calibrated by SID personnel who may have left the employment, because sometimes these cases will be a year down the road before they ever go to trial. Trying to track those people down and to find them so you can subpoena them in, so you don't have to go back and redo the work in some cases this way. So it is a huge challenge, but everybody's working hard to see how we can mitigate that.
Was that a published case?
Yes.
So it's, all right.
We've been joined by Councilmember Zine also. Any other questions on this?
Could you give me the name of the case again, or?
Melendez-Diaz v. Massachusetts. I believe the decision was on June 26th.
And so I understand it is basically no more hearsay. The individual that actually does the testing must be present.
If called, yes.
If called.
That's right. Unless the defense can still stipulate and, all those sort of things. But if they don't, the original analyst must be present in court.
Okay. Let me just ask one thing. A while back when we had some of these hearings, because it does get confusing when we say that the backlog is down, and then if we don't ask the question, which backlog, then we go down a path of public believing we only have 2,000 cases left. We were advised at some point we would start getting information as to rape kits versus overall backlog, so that we could monitor or be aware of what is in the system from homicides or any other cases. And I'm just wondering if that is forthcoming.
I can give an approximation right now. As was previously reported, we have 4,168 rape cases that are backlogged. We have approximately 200 to 250 non-rape cases backlogged.
Those are just kids that have been, cases that have been sent to you by detectives, not, because I know there's a lot of DNA evidence out there in homicide cases, burglary cases. We haven't even begun to scratch those surfaces yet, so.
That's correct.
We've scratched them, but we haven't.
We scratched.
We still have a long way to go, yes.
Right.
Yeah, okay.
So this is what's in the lab.
It's just in the lab.
It's what we have a pending, either it's in progress or what we have a request for analysis on.
So we're
Correct.
saying there's still a backlog of evidence that hasn't gotten to the lab?
No, sir. Of this number, the 4,168, those are sitting in SI, or sitting in property division, rape kits either waiting to be analyzed, that have been unanalyzed. There is, when we went through and did our search of the freezers, when we counted frozen evidence, there was over 53,000 items of frozen evidence that we went through in those particular freezers. That number that we have right now are untested rape kits. I don't have a good number for you now on untested homicides and the like.
Because I think that's what we were told, that at some point we'd get that.
We're working towards that, yes, sir.
Analysis of that 53,000 or something. Do we have a timeline on that?
I don't have that for you now, sir, no.
And then let me just ask, let's see. Another thing that a while back we asked for I think the CAO to look into with the department is what is the cost effectiveness of comparing the hiring of people versus sending out the contractors? And do we have a tipping point as to the cost? Because when we're dealing with personnel, we're paying pensions, we're paying all that other stuff. But is there a sense of, and then we were told at one time that there was a shortage of contractors to accept the evidence, and then we were going to get information back as to whether that group of contractors was expanding.
Actually, this might come under item number 2. Do you want to wait till then?
Okay.
Why don't
Are we dealing with 1 and 2 at a time?
I think we're just dealing with 1 for now. So why don't we ask you to report back in 4 weeks with the next report, and then we'll go on to item number 2.
Item 2,
Yeah.
CAO report relative to Police Department forensic DNA analysis staffing, backlog, and funding.
We'll stay in case there's additional questions.
Matt Crawford from the Office of the CAO. As you can see from the report, our office's involvement in the report in front of you is basically to transmit it from the department to the Budget and Finance Committee in the regular budget process. Most of the meat of the report will come from the gentleman to my right, but I'm here to answer any questions we can regarding the financial side.
Okay, well, just working down the items. One of the issues or questions was non-general fund sources of funding for DNA analysis. In the report, it does mention a number of current grants that we have, the 2007 Forensic DNA Backlog Reduction Grant, which has since been utilized. There's no funding left in that one. The 2008 Forensic DNA Backlog Grant, we have some funding left in that. It is included in our estimate of cases we're going to be analyzed. There's actually about $180,000 that's going to be used for outsourcing out of that grant. There's a 2008 Solomon Cold Cases with DNA. That deals an awful lot with not just rape kits, but a lot of variety of other cases. And there's about $500,000 available for outsourcing. And that's currently being used on a variety of cases, not just the rape kit backlog. Coming up in 2009, we do have another federal grant, 2009 Forensic DNA Backlog Reduction Grant, which is a total, I believe, of $1,023,151. Again, as a little bit of background, it's called the DNA Backlog Reduction Program, but it's for reducing the backlog and increasing capacity so backlogs don't grow. Historically, they used to exist as two separate grants. The last, I think, 2 years they've been involved in one. So we use some of the funding for outsourcing to reduce the backlog of rape kits. We use some of the funding for equipment to help equip the people that the City Council has given us to add to our staff, along with training and some overtime. So it's used for a variety of purposes. But about $500,000 of that grant will be used specifically for outsourcing cases in the DNA rape kit backlog reduction program. Again, there's a Solving Cold Cases grant. I am not sure how much of that is going to outsourcing. We are pending on a couple of other grants that we put in applications for, but it's unknown at this point whether or not we're going to be receiving those funds. In addition to the grant programs that we have, Proposition 69, which was voted in, I believe, in 2004, provides funding for uses in DNA analysis. As long as we're working on eliminating the backlog, the majority of those funds goes towards outsourcing kits in the rape kit backlog reduction program. And finally, there is the Police Foundation, which seeks donations to assist us with backlog reduction. And so far, that has been in excess of $1 million. So it's had an impact also on our ability to work on eliminating the backlog.
As far as the question for Councilman Parks, I'm not aware of the tipping point or that an analysis of when it becomes more prudent to hire our own or versus contracting out or outsourcing those particular kits. I do know that it's $1,000, essentially about $1,000 a kit to outsource. So it's quite expensive, so we're paying quite a bit of money to that. I'm not sure, Greg, if you are aware of any.
No, we don't have any current studies on what it costs to do it in-house. Obviously, from just a dollar cents point, we could come up with a figure on that. We've historically had issues off and on with outsourcing companies having capacity to not having capacity. I mean, we are in competition with their services with the rest of the country. One of the questions you asked was what their capabilities were, their capacity was. I mean, we've come here to this committee several times, sometimes saying they were maxed out, they had no more, other times saying that they'd increase their capacity. It changes from month to month. At the moment, they're able to handle pretty much every case that we have. We currently have 4 contractors, 2 that are very large that handle the majority of our cases, and 2 that are on the smaller side that we use for in the neighborhood of 10 to 20 cases a month. So they are a help, but they're not a big impact on our process. Bodie Technologies and Orchid Cellmark are the two largest. To give you an example of how their capacity can change, Orchid Cellmark has two laboratories. They have one in Texas and one in Tennessee. Historically, the Texas was their forensic lab. The Tennessee was a paternity testing laboratory. About 4 months ago, 5 months ago, they let us know that they were taking on extra casework in Tennessee to handle rape kits. That didn't exist before. They had staffed up and trained some people, so that allowed us to send them more cases. But they may enter into contracts with other agencies, and their capacity could drop again, or they could lose people. Plus, the Melendez-Diaz case may end up with their staff all over the country testifying and cut down on their capacity.
So in addition to being not entirely reliable in terms of workload, we actually have no idea whether or not we're paying more to outsource than to do it in-house.
Well, that's correct to a certain degree. Part of the problem has been capacity at where our current staffing levels were at. That was the big issue of initially how that works overall staffing levels. There's no way we could hire enough people to analyze all of our backlog kits. What we're hoping to have done is in our plan that where we have identified how many people we would need over the next few years, in which the council has been generous to supply us up till now, has, we think, will help us once we get through this backlog to handle our everyday needs. And that's where we're going for. At some point, and hopefully in the year 2011, we will not have to outsource anything except for maybe some specialty items, but for the most part, we will handle everything in-house. That's the goal.
Now, this year's budget, we added 26 new positions.
That's correct.
How does that impact the need to outsource?
Okay, the way this works is in the last fiscal year, we received 10 criminalists. We determined a while back that that's a maximum number we could receive in any 6-month period to bring them on, train them up, and get them into working on the cases. With the 26 that we have coming in, 20 of those are criminalists, 4 lab techs, there's a Crim 3, which is a lead position, and a clerk typist. But we'll focus in on the criminalists. We will be hiring the 10 as soon as we are able to do so. Wait 6 months, hire the second 10. When the first 10 are brought on board, the 10 that we currently have involved in outsourcing our backlog cases will be shifted from that into screening training and screening cases in-house so that we don't have to send those out. The 10 new ones will be assigned to handling just the straight outsourcing of the sexual assault kits. As soon as the 10 screening ones are up and going, we can take those and start training them in profiling. Those are the 2 main steps in DNA analysis. You screen it, look for the evidence. Once you find something, then it goes on to DNA profiling. It's this stepping process of where we bring people in, have them become effective, assist with the backlog and getting them out the door. The next batch then increase their capacity to do cases in-house so we don't have to send out so many.
So in the following year, you'll have everybody up to speed, and it'll be more effective.
You'll have them up to speed doing something, yes. It normally takes anywhere from 18 to 24 months from time somebody's hired until they are fully trained DNA analyst.
And what's the status of the application for federal stimulus money in this arena?
I don't have the current, I don't know where it is right today, to be honest with you, sir. I can find out and get back to you. But we have applied. We have been told we've been granted our request. But where it is right now, I'm not sure.
Thank you. Any other questions?
I've got one regarding the equipment. I've been told by some folks in the field of DNA testing that we don't have the state-of-the-art equipment to do the testing, that it can be done a lot more efficient with different equipment. Do we have the state-of-the-art equipment to
Yes.
do the testing in the most efficient manner?
Well, most efficient is the next question.
Okay.
We do very much have state-of-the-art when it comes to the analysis process, the amplification, the genetic analyzers. Those are all current state when it comes to any laboratory out there. The one area that we are in the process of validating are the robotic systems that allow us to increase the throughput, and we have some that we purchased under grant several years back online, and the new grant that we have, we're going to be purchasing additional ones. So at the moment, our robotic systems are 2 to 3 years old. The next round will be that much more efficient.
And that will speed up the process?
It should, yes, yeah.
Okay.
Allows you to do more samples at one time.
Right, okay, thank you.
Let me just follow up, so I understand. The people that you mentioned earlier that send material out and then reassess it, are they the same classification as those who actually do the analysis?
Yes, they are.
Okay, so the thing is, it's the same groups that we've been hiring, so there's not a level in which their entry or less proficient, they do all of it at some point.
Eventually, they will be handling everything from beginning to end, yes.
And then the other issue is that, as I was asking it earlier, one of the things I think you mentioned, and it's in the CAO's report, at some point we'll be at the level that we will not be sending, we hope not to be sending cases out. And I think that's why we asked the CAO at some point to get with you and figure out what's the most cost effective, so that if we get to the point that we are not sending them out, or we spending our money wisely, because if we've just hired 16 and then we're going to hire another 26, and we have to pay overhead and pensions and all that other stuff, is that more cost effective than having a portion of those going out to contractors? I think that's what we're trying to get a sense of, so that we don't lock ourselves into one area or the other. And so if we can ask the CAO to look at that for us. The other thing on, and I didn't quite understand on item 2, the chart, on the second to last page, and maybe you could just walk us through that on the sense of stranger and then the non-stranger. I couldn't quite figure out on the pending cases, when they're labeled as cleared by arrest or cleared other, how would they be labeled as pending? I just couldn't figure that one out.
One of the questions we had, I believe what that is that there's certain cases where they were not stranger rapes, but they were acquaintance rapes, where the individual was identified, but the kit was never analyzed. When you would run the individual who was identified as the suspect in that particular case, we found that many of those were already uploaded into CODIS. Those individuals were already in CODIS. So the question became, is it necessary then to analyze that particular kit when that has already been accomplished? So we put that pending down the priority scale. Our intent is to analyze every rape kit, but as you would expect us to do, we prioritize them. What we found out of those nearly 7,000 kits, that 600 of those individuals that had been identified on acquaintance rapes were already in CODIS anyway, so it doesn't make it as large a priority, so that's why it's pending.
Maybe, what's the definition of pending? That they've already been put in the system?
But the kit hasn't been analyzed.
Okay, okay. And then my final question is that, and I think it's just a matter of clarity, and I think it's important as we talk about this over and over again, that when you talk about backlog, that for those who don't follow it, that we consistently say what the backlog is, in the sense it's DNA for rape kits.
Yes.
Because at some point you're going to bring us the bill for the 53,000
other items,
and we're going to all believe that your backlog is finished, when in fact it's not. So I think we need, in that verbal exchange, as to when you say the backlog, that it's clearly defined as DNA backlog for rape kits, because I think there's a bill coming at some point about all this other cases when you get through your analysis, so that we not condition the council to believe it's done. I think we have to always keep open that you have a lot of work to be done that's going to be costly. Until you finish your analysis, we just don't know how costly.
Yes, sir. I agree. That's very, very important.
Any other questions? If not, we'll note and file that report.
Council members, Mr. Koretz, before moving on to item 5, the CAO has a technical amendment to item 4, so you can present now for consideration.
Good morning, Melissa Fleming with the CAO. Thank you for reconsidering this item. I'd just like to make one technical correction to the CAO report. Recommendation 1F authorizes the execution of a contract with Tetra Tech Incorporated and includes the date March 31st, 2009 as the completion date of this contract. We'd just like to correct that. The date should be March 31st, 2010. So we just request that the committee approve the recommendations in the CAO report with that one modification to recommendation 1F.
Without objection, we'll approve that.
Thank you.
Next up on the agenda is item number 5, Fire Department to present a verbal report relative to the Sepulveda Pass July 8, 2009 brush fire near the Getty Center and Mount St. Mary's College. I'll let him know. Am I speaking this item?
Good morning, Council. Mario Rueda. I'm Deputy Chief of Emergency Services with the Fire Department, and I was the incident commander Wednesday, July 8th for the Getty Fire with my counterpart from LAPD, Terry Hara, Deputy Chief. If you'd like, I can go ahead and just give you a brief verbal report. At about 13:30 hours, 1:30 in the afternoon, the Los Angeles Fire Department was alerted to a brush fire in the Sepulveda Pass. That fire was on the west side of the Sepulveda Pass, primarily topography driven. We had mild winds out of our southeast, which is prevalent in the summer months, not wind driven, and basically ran the topography in the Sepulveda Pass. Prior work that we had done with our tractor unit really provided a barrier on the west end, which prevented it from slopping into the canyons to the west of there, and really helped contain that fire. An additional barrier provided by our tractors that day prevented the northward fire spread. Also, a significant commitment of ground resources, nearly 50 companies of firefighters, combined with aerial assault by helicopters from both Los Angeles City and Los Angeles County fire departments, helped to contain that fire to about 80 acres. Los Angeles Fire Department was committed there for approximately 2 days, continuing with mop-up and ensuring the fire was out and that no embers spread. The cause of the fire was determined to be the result of brush clearance efforts. One of the brush clearance workers from the Getty placed the weed whacking device up against his leg. His clothing caught on fire, and he dropped the machine. We're not sure if the clothing or the actual dropping of the weed whacker into the brush caused that fire, but it is attributed to brush clearance, which we encourage, but brush clearance in their Getty property. The fire was contained to Getty property. With respect to brush clearance, we do encourage that, but we do find that many brush fires are the result of brush clearance activities in our wildland areas. We do encourage folks to hire a licensed contractor to do the work, mostly because they're bonded and they are used to doing this kind of work, but when the public does perform this work, we ask them to keep a fire extinguisher nearby. To the best of our ability, we are having fire prevention look at whether there are non-sparking tools that can be used, but we do find that many of the fires are actually caused by sparking tools. And we do ask that the public have their machines in good order so that spark arresters are in place and they are aware of where they're at, and they do have a plan in place in case they do have a fire. And that concludes my report, unless you have any questions.
Now, when the city hires a contractor, are there standards that we apply to make sure that it's less likely to cause this kind of sparking, and that we're likely to be able to put it out quickly if something like this happens?
I could answer in general, but I'll let our expert, who actually hires our contract brush clearance folks, to answer that question.
Good morning. I'm Captain Robert Knight from the Brush Clearance Unit for the Fire Department Fire Prevention Bureau. We utilize licensed contractors who have to comply with our requirements on safety that they have to use when they're doing brush clearance. Water gun extinguishers have to be readily available with a member posted by it. They have to have helmets, goggles, gloves, safety vests if they're working off of a highway or traffic cones, so they can be safe when they're working next to a highway or a street or road. They are required to bring all that equipment in. We inspect it, we check it off. There's a checklist that we go by, and that is proven to be effective with our brush clearance contractors. Also on red flag days, when they've been declared by the fire department, brush clearance is not allowed on those days, so to make sure that our hillsides are safe.
And what about when it's done by private contractors, and I assume that's the case in this case, are those same standards applying, or are there other standards that apply?
As far as right now, the fire department does not make those requirements on a private homeowner or other private contractors. The only contractors that we impose that requirement on is the ones that are contracted by the City of Los Angeles.
And what do we know about this particular case? What safety measures were being used by the folks that were doing the brush clearance when the fire was caused?
The Fire Prevention Bureau has not contacted the Getty maintenance personnel. We intend to. It appears as though this was a careless act. Perhaps the cap of the fuel tank for the weed whacker was not secure, and that leaked and ignited the fire. So this is obviously a safety consideration that needs to be addressed with the Getty maintenance personnel.
Now, I know there actually is, I believe, someone here from the Getty Trust. Maybe we can ask you to speak on this at this time, since I know you have a card in to speak anyway.
Thank you, Mr. Chairman. I'm Ron Hartwig, the Vice President Communications of the J. Paul Getty Trust. Glad to answer any questions you have. I want to start just by saying, first of all, thank you very much to the City Fire Department, County Fire Department, Police, and all of the agencies that responded. They did an incredible job in a very rapid time. Let me give you a little background on our procedures at the Getty. We actually have a team of 20 people who are dedicated to brush clearance. 15 to 17 of those are based at the Getty Center. They're highly trained, and they embark on an annual brush clearance program beginning in the spring and then working through the summer. They have the best equipment that is available to them. We don't use metal blades. We only use nylon whackers because it is less prone to cause a spark. They are accompanied by fire extinguishing equipment, and they actually wear fireproof jeans and clothes so that they're not impacted should what occurred this time happen. This was an accident. I must say we are in the process of talking with the grounds people ourselves. You can imagine Wednesday there was a great deal of confusion. Thursday we were closed because the roads around the Getty still were closed. But beginning today, our folks will be talking with the team to find out exactly what took place as well.
So you don't know why this would have occurred, because it would appear that the safety measures that you use should have prevented this from happening in the first place.
That's exactly right. And just to bring a little perspective, as you know, we have 750 acres that the Getty owns. About 110 acres of that is actually developed, and 24 acres are committed to the buildings at the top. We work closely with the fire department to develop a perimeter plan around any housing, for example, or around our buildings themselves to make sure that the brush around those areas are cleared. And in fact, I think it was last year that we worked with the fire department to actually construct a new fire road, which was actually very helpful in this project. So you're right. Until we have all the facts in hand, we know it was an accident. We certainly know it wasn't any intention to start a fire. And we certainly know that we work very closely with the fire department. And I might add, to the degree that we can work with the fire department to either look at new equipment or look at new procedures, we absolutely want to do that. I think we have a good track record of working with the fire department.
And I'm not sure which of you would know, is this property entirely in the city of Los Angeles, or is there any of it that's outside the city?
No, this property is entirely in the city of Los Angeles, and it butts up against the Santa Monica Conservancy property. This fire was contained to Getty property. And as was stated, our work with the Getty over the last several years in constructing fire roads on their property did prove to be instrumental at this fire in containing the fire, actually to our greatest exposures, which are the houses west of the Getty property.
Other questions from council?
I'd just like to add for the record that Getty is a wonderful neighbor to the city of Los Angeles, a wonderful benefit to the city of Los Angeles, and they do a lot of good for the city. As far as the arts and the other culture that's generated there, a lot of fundraising, they're a worthy organization, so I want to give Getty credit for the good they do. The question I have is regarding an incident that occurs because of an accident and the resources, the helicopters, fire equipment, et cetera. Is there a charge back to the property owner for that service rendered, such as we do with ambulance service, or no?
No, we do not. Ambulance service, we always charge the individual that's transported for our standard fire protection. That's what the taxes pay for.
Okay. Okay. Thank you. I have another question on when they have the personnel that are doing brush clearance, not necessarily Getty, but any other location, the ones that are contracted, are there any site inspections by fire department personnel to make sure they're doing appropriate maintenance, cleanup, et cetera, following the property guidelines?
Yes, sir. Any property that has been contracted out by the fire department's brush clearance unit, we have inspectors that are assigned to go and observe and view when they're out there doing their brush clearance to make sure that they're doing it correctly and it brings it into compliance with the fire department's requirements.
Okay. Thank you.
Other questions? We have one other speaker, I believe, Mrs. Patricia Hurst on this item. Present? Not present?
She's ready.
Oh, okay. If she'd like to speak as well.
Good morning. My name is Patricia Hurst, a Brentwood property owner, a community activist, leader, organizer, all the words we've heard for years, for over 50 years. I'm here today to speak to the issue of the Santa Monica Mountains and its surrounds, because that's where this took place. I was the caretaker of 2 families due to the Bel Air fire in 1961. I had adults, screaming and crying children, dogs, cats, and goldfish, and their biggest question was, what do we do next? The city has 80,000 permits across the desk of the planning department. For future development, we have a water shortage, and we have a fire department that is stressed to its capacity with the fellows on the line. We need to be proactive and not reactive on this. I'd like to see some beefing up of the codes, if there are any, that really deal with this high fire risk area that we are speaking to today. I don't think we can wait, because the fire season is upon us. It's coming in less than a month and a half, and that's when anybody in the Brentwood area, whether it's Mandeville Canyon, which is landlocked, Bel Air Crest, landlocked, and Mountain Gate, landlocked, involving thousands of people that are landlocked. that cannot get out on Sepulveda or the 405 if there's a fire in that area. And Mandeville, forget it. They're toast. Excuse the pun, not intended. The neighborhood councils, the neighborhood community associations, homeowner associations, and myself would be glad to sit at the table with 5 or 6 people from the fire department, Department of Transportation, a rep from the police department, certainly from your office, Mr. Koretz, and anybody that's in the CD. I'm going to wrap it in one.
Okay, you only have 2 minutes, but since I didn't mention that, I'll give you a little extra
But I'm
time.
very concerned about this, and I think that there are ways to deal with this. The closure of Sepulveda, you all have my letter that was sent to you on Friday. It's it's a one-page letter with the 1961 fire recommendations and the issues of concern that it brought to my attention. My interest in this was piqued by 2 phone calls from 2 national newspapers, knowing I am a Brentwood resident, and because of the Hearst publication stuff. Bottom line is, I gave no report, no information, because I had none, but I said I'll get back to you in 2 weeks, because I know that through the divine intervention from Sunday at
I'll have to ask
church,
you to wrap up.
that you will give guidance to the fire department and to the community to make this a less dangerous issue. John has distributed the information. I will follow up today, and I'm going to ask for a copy of the tape from this presentation. Thank you, John.
Thank
By the way, I have the methane map of the 2 landfills that border this area within 2.5 minutes of that fire. 2 producing methane landfills.
Well, I have at least one suggestion that I would make, which is, I wonder if the fire department could come back with any suggestions for possible regulations on private contractors and brush clearance, so that we could look at setting some standards for that. I don't know that the Getty necessarily would violate the standards that we would create even, but I think it points out an opportunity, since we've heard that a number of brush fires have been caused by people clearing their brush for the purpose of avoiding brush fires, that it might be logical for us to look at some standards. And any other questions on this item?
I would just ask if we could ask the fire department to respond to her letter.
Please.
To the letter when we come back?
Yeah.
Much of it is true. The Sepulveda Pass does represent one of our most significant fire corridors. The brush there hasn't burned in 30 to 40 years, and keeps me awake at night.
Maybe you could come back in 2 weeks with that response.
Yes, sir.
Thank you.
Thank you. Thank you.
We could have the next item.
Committee members, item 6. Board of Fire Commissioners report relative to the Fire Department's 2008 brush clearance assessment hearings report and proposed appeal decision and recommendations.
Okay, if we could have the fire department give its report, and then I'll call up 5 people who have requested to speak on this item.
Again, Captain Robert Knight from the Brush Clearance Unit of the Fire Department, Fire Prevention Bureau. Annually, the Fire Department conducts brush clearance inspection sweeps for the very high fire hazard severity zone, which is about 161 square miles of the city's hillside communities that is prone to brush fires. There are approximately 132,000 properties that are located in the zone that have to be inspected annually. The fire department does this inspection beginning in May. A property is found to be in noncompliance. The property is then cited and issued a notice of noncompliance to the property owner on record. The property owner then has 20 days to comply with that. The fire department goes out and does a re-inspection of that property to find if the property was actually cleared of the hazards that were found. Property owners who fail or refuse to clear their property by their due date are then issued a second notice of noncompliance to clear their brush clearance. Those property owners that still continue to keep their property in noncompliance are then packaged into a bidding session with other non-compliant properties, and those properties are awarded to contractors to go and clear those properties and bring them into compliance. The property owners will be assessed the cost of that clearance, plus an administrative fee and a non-compliance fee. The report that's before you in the blue book is the proposed report and decision that's by the hearing officers who, property owners who wanted to appeal those charges. Their decisions are right there in that book for your review. And we guess we have 5 speakers here that's here to contest those.
I'm Janet Jackson. I'm the Fire General Counsel of the Los Angeles City Attorney's Office. I work with the fire department, and I work directly with Captain Knight. The process that the homeowners go through for their appeals is found in Section 5703.05 of the Fire Code in the Los Angeles Municipal Code, and it does afford the due process rights to the homeowners. They are first given an opportunity in the middle of the process to meet with the city attorney's hearing section in order to receive clarification about the nature of their property and what it takes to get into compliance. Once they have gone through the process and either cleared their property or had the property cleared, they have the opportunity to appeal the assessment of any fees. That power is given to the Board of Fire Commissioners or their designee. In this particular case, the Board of Fire Commissioners hires independent hearing officers that actually conduct the hearings, and what you have before you are the actual results of their hearings. And I'm here to answer any questions that you might have regarding the hearing process or the RFP process that is utilized to hire the contractors that clear on behalf of the city.
Before we begin this, I'd like to ask the city clerk to give us the possible choices that we have as directions on these cases.
Yes, sir. A number of speakers' cards have been submitted. You can now open the public hearing and hear their comments. Following that, the committee would make a recommendation to either deny or grant in part each of the appeals that are before you today. That would include not only those who speak here today, but any appeals who have been filed. The committee also has the right to request additional information from the fire department should they need it at this time. As was the case in previous years when an appellant may have made a presentation, if additional information was needed, the appellant may work with the fire department in the ensuing days and then report back as made by the fire department at the next public safety meeting. So your action today is to hear the board's report and to approve the recommendations for the appeals, and also to deny the appeals or to grant any of the appeals you may hear today.
Okay, the first speaker is Michael Drucker, and I believe his case is on page 33 of council members' packets.
Good morning, council members. My name is Michael Drucker. I'm an attorney in Los Angeles. My client is Alan Shark. He owned a vacant lot in Studio City. He purchased it 2 years ago in 2007. He never received notice of the proposed action. He has a business on Van Nuys Boulevard near the Van Nuys Civic Center, which is his mailing address according to the county assessor and the LA County tax collector. The notice sent by the fire department apparently were sent to another gentleman at an ad of which Mr. Shard has no connection with, and it was sent to an address in Encino. The vacant lot is in Studio City. Mr. Shard's mailing address is in Van Nuys. He had no connection with the address in Encino either. We presented evidence and exhibits that are also in the supplemental declaration that I have submitted. The hearing officer recommended that the administrative fee be canceled. However, they still assessed the fee for the private contractor. Mr. Sharg objects to that based on the fact that he was never provided due process or an opportunity to clear the brush himself. Subsequent to the hearing, he's received another bill from the fire department for inspection and reinspection for $300 plus a $150 penalty fee. That notice was never sent to him either. It was sent to the address in Encino to this other gentleman, and we are going to be contesting that as well. Thank you very much for your time.
Go. I have a question. If he owned the property for almost 3 years now, he's cleaned it before, obviously, he knew what the rules were.
He owned it for 2 years, Mr. Smith. He cleared it for this current year. I don't know what happened at the year before.
Fire department?
The subject property, there is a vacant lot that's west of 124 Laurel Terrace. The information that the attorney here is presenting, that the notices were sent to the wrong address, is correct. The fire department did acknowledge that, and the hearing officer did waive the fee because of the wrong mailing address. However, we notify the property owner in two ways. One is by mailing to the address, and the other is by actually posting the property itself with a notice of noncompliance and a violation that exists. Both were done, and also the property owner is aware that the property is located in a very high fire hazard severity zone, which has to be maintained on an annual basis. And because the property was in noncompliance, a hazard existed, the property was brought into compliance by our contractors, the cost of clearance should be assessed to the property owner.
Yeah, I get all that. The question I asked was, I was talking about their past performance. Had they cleared the property properly last year?
That information I don't have on record, but I can look that up to see.
I appreciate you knowing that, because if the guy did it before, he obviously knew what the rules were. So you can't claim that he didn't know just because he didn't get the notice at the proper address. I'm willing to go along with a waiver of that fee because the city made a mistake. Administrative fee. But the property was cleaned, and you didn't do it, we did. So you have a benefit that you got from us. I think you need to pay for that. The question is, you obviously knew the property owner knew he had the property, and these were the rules because he had probably cleaned it the year before. But that's what I want to hear when we come back then. Sure. When you bring it back.
Okay.
What about that, the second fee that the property owner's representative mentioned?
What I believe what happened there is that non-compliance fee is assessed to property owners who do not comply by their deadline, their due date. They're assessed a $300 non-compliance fee. If the property owner wants to appeal that, they must submit a written appeal to the Board of Fire Commissioners and would be reviewed by the hearing officer. I would have to look in the records and see if he actually submitted a written appeal, which would have gotten a waiver on the non-compliance fee. It appears that he doesn't, so that would have to be looked into.
Well, it seems to me that if we're waiving the administrative fee because they didn't receive notice, we would logically waive the non-compliance fee as well.
That's correct.
So I would suggest that we grant him his request, both not to pay the administrative fee, which was already recommended, and not to pay the non-compliance fee, and simply charge him for the services that the city did supply in clearing that brush.
Yes, sir.
The difficulty, sir, is that the Janet Jackson City Attorney's Office, the additional fee that he is speaking about is not before this body, so we're not exactly sure what it is if it is not part of the current appeals hearing process. And this board wouldn't have the jurisdiction over it at this time.
So we would have to wait till it goes through the process, even though I think we would logically know what that result would be, since it would seem to be in keeping with the concept. If you're not going to charge him the administrative fee because he didn't receive notice, you certainly wouldn't charge him the non-compliance fee either.
That would be correct, but for the fact that it's not before this board.
But also you have to figure out whether all the information is accurate.
We haven't seen any information.
Yeah. Let me just ask, what's the confusion on the address?
The addresses that we utilize is the address that's on record with the county
Is that
assessors.
what, the property tax record?
Correct.
So if we're sending the address to that location, then that's where his property taxes are also going?
That is correct.
Okay,
Chief, on the supplemental declaration, I attached Exhibit 4, which is the property tax bill, showing the address on Van Nuys Boulevard, and also Exhibit 3, which came from the fire department, showing the county assessor parcel information. That has the address as Van Nuys Boulevard also, not in any address in Encino, which Exhibit 1 reflects the copy of the bill or the invoice, and that stated the address was on McCormick Street in Encino. So the records, according to the fire department, with all due respect to the officer, they were using the wrong address, even though the correct address was available to them from the tax collector in the county assessor's office.
and I realize it's not before us, but what's the timing of this issue and the second issue as far as the department being able to correct the address once we've been put on notice on this issue and we're waiving the fees? Would we immediately correct the file for any future notices?
Absolutely, yes. As soon as we became available of the new supplemental address that's been provided, that would be updated.
Mr. Chair, I make a motion that we waive the administrative fee on the $1,026 and assess the $400. I think it was $400.
I'd second that.
$400 fee and waive the $1,026.
And just verify for us that at some point that the address is correct now.
Absolutely. Address has been updated, yes.
And I, as I understand it, for the benefit of the applicant, the administrative fee is waived, but the charges for brush clearance are still maintained because even though it wasn't exactly voluntarily, you still received the service of the brush clearance.
Yes, sir, that's correct.
Okay. Thank you.
Thank you very much.
Thank you.
Next item is, or the next speaker is Jacqueline Cabrera, and I believe that's on page 106 of your packets. Assuming Jacqueline Cabrera is present.
Are they here?
For the moment, we'll go to the next one, see if
Fill out the card.
she shows up. She did fill out a card. Let's see. The next speaker is Charlotte Reed, and this item would be page 132.
Hello.
You have 2 minutes.
Yeah. My name is Charlotte Reed, and this is regarding the property. It's really actually in the city of West Hollywood mainly, and there's a small strip that belongs to the city of L.A. And the address is 8349 Sunset Boulevard, and it's a vacant lot used for parking. And there must be some error because I think they had the address of 8343 instead of 8349 Sunset Boulevard. And 8343 Sunset Boulevard is a house way above, right above the lot. And it's all gated with a lot of shrubbery and dead leaves and branches, but it's gated and they have big dogs, and we couldn't go there to get the work done. And every year we clear ours. In fact, it's so bare, there isn't anything on there. It's like bare mountain. We take care of it every year. I've had the property for about 12 years, and we never had any problem with the city of West Hollywood or anyone else, and it has to be a mistake. I went for a hearing in Van Nuys I explained it to them, but they didn't seem to understand it too well. And the reason I went there, they had sent me something in the mail to pay $350, and they said if it wasn't paid within a month, I'd have to pay penalties and a fine. So what I did, I sent in the money. I sent in $350, and then the next thing I know, a few months later, I get this other letter that I owe $328 plus $1,000 administration fee, and I couldn't believe it. That's why I'm here.
Any response from the fire department?
Yeah, the fire department inspected the property back in May 1st of 2008. The vacant lot, it is approximately 145 feet south of the address of 8343 Sunset Boulevard, which is a vacant lot. That's a little small strip of a vacant lot there. The property is located in the city. One of the issues that the appellant has is a property line issue. Any property owner who disagrees with the fire department's measurements, that it utilizes the parcel maps that are provided by the county assessor's office, they must provide proof by either securing something from an authorized land surveyor to show that the fire department's measurements are off. That was not provided to the fire department, and so therefore her appeal was denied.
I didn't want to have to hire a surveyor because that would cost me several $1,000s. I thought that's very unfair.
How do we usually deal with this kind of situation? If it's a small strip of land, then it would cost more to survey than to deal with the issue. What's the usual process, or is there one?
That is the process, sir. It's just if they disagree with what our dimensions are, that we took our calculations of where the property line begins and ends, they have to show us proof to prove the fire department is wrong. Our inspectors are trained to utilize these maps and use rangefinders in order to determine these lines. Fire department followed this procedure.
Now, how long have you owned this property?
About 12 years. And I never had any problems before. I take care of it every year.
Now, what would have happened in previous years? Why would this year be different?
It appears as though that this hazards were found when the inspectors went out there to inspect it, as they do annually, and clearly there was some violations that were found, and work was done on it.
How large a strip is this?
I don't have that information that's exactly right here, the dimensions of how large the lot is, but it appears to be a relatively small lot for only $300 for the cost of clearance.
The city of West Hollywood was very satisfied with the way we take care of it. The fire department.
Captain, when you had the hearing, did you show Mrs. Reed the property lines, the maps that you have? And did she agree that those are the properties in question?
I wasn't present at her hearing, but that was provided for her, and that was at the hearing. It was available, and if she would like to see those again, they're still available for her, yes.
I cleared all the mountain way above what I own, all the way up to the road on all sides. I just can't understand what they're talking about.
Do we have a motion? Any thoughts?
Well, I'm thinking that since there was a question on it, if we could have the fire department, the inspector, return with Ms. Reed and see if they could verify the area that we're talking about and have it continued, so we're fair and objective with the matter. So I'd make a motion to do that.
I'll second that.
They're going to go to on-site?
On-site inspection with the appellant.
And bring all your pictures and maps.
So Ms. Reed, we're...
Yes, sir.
we're moving forward with having you return to that location with the fire representative.
fine.
And then check it out, and then we'll hear it again.
Will they give me the date and time?
Oh, they'll set it up with you. Yeah.
Okay.
At your convenience.
Thank
You'll be
you
there,
so
you'll
much.
be there, and they'll be there.
We'll
I
contact.
appreciate that.
Okay.
We'll do that.
So, Mr. Chair, we continue that one.
And should we have a report back in 2 weeks? What do we think
How
is
long-
reasonable?
How long do you think?
Well, the department's on a pretty tight deadline moving forward. As was the case in the past, we continue for 1 week. Department will meet with the appellant and then report back next week for final action by the committee.
So you have a week to coordinate time and location.
That's fine. Thank you very much.
Thank you.
Yeah.
The next speaker will be Linda Turner, and this will be found on page 95 of our booklets.
Good morning. My name is Linda Turner, and my property is Beverly Hills PO, but it belongs to Los Angeles. And actually, I lived there for a long time, and every year I hired a neighbor's gardener to clean it, brush, and never had any problem. And last year, inspector came and said, wasn't satisfied, so I said, okay, I'm going to call them back and keep on cleaning. He said, who did you call? I said, it's a neighbor gardener. He said, that's against the law. You have to go into Los Angeles Fire Department website and showing all those city contractor brush clean people. So I said, I didn't know. So many years I just hired neighbor's gardener to do the job. And only cost me about $250, $300 most. He said, no, you can't do that. So I went to the website and called those people. They asked me over $1,200 to do it, which is I cannot afford, because last year my husband passed away December 11th. And due to the bad investment, we lost all those money. So actually, we've been living last few years, depending on his Social Security. And since I don't work, we don't have any Social Security, only his. And he passed away last year, December 11th. So actually, I lost Social Security income December, January, February, March. I'm sorry. And I filed for widow's benefit, and I started receiving April. So actually, I cannot afford it.
Do we have a hardship process? What do we do if
I have last
people
2
can't
years
afford to pay?
tax return filed with me.
A hardship process is allowable in certain cases. The hearing officer normally will do that if the appellant has valid reason and provides proof that it would be a hardship to pay for the cost of the assessment. Perhaps maybe that was not provided at the time of the hearing, and I don't know if that's available now, but there is a case for hardship, yes.
And what kind of proof do we usually look for?
Usually bank statements, something of that degree of what is your income, a source of what income you do have, and what your liabilities are.
So what would the logical process be to have you work with the applicant and ascertain whether that's the case in this case, and perhaps come back in a week and let us know whether that exists?
Sure.
And the hardship would be exempting on just the fees, but what about the service, the $900? Is that attached to the property as a lien or what? And
It normally gets added to the property as a lien, but it would still be the determination of the hearing officer to determine if they would like to waive the entire amount or just the fees, or reduce or modify the amount.
Is this a vacant piece of property, or is this one with structures?
It's surrounding structures. but it looks as though it's a vacant piece of property. It doesn't say vacant lot, but it just has a Briarcrest Road, so I'm assuming it's a vacant property.
If we could have a,
Is this a vacant lot or is this a residence?
I believe looking at her address being on Briarcrest Road and the situs location being Briarcrest Road, it could be a home that's adjacent to it, so I would assume that a structure is right there. So it'd probably be her personal home. Is that correct? Ms. Turner?
I'm sorry.
This is your home?
Yes.
Your house is there, yes. That's what I thought.
so I guess an appropriate motion would be to have you come back in a week with, having conferred with the applicant about her financial status and whether a hardship application would be appropriate.
Okay.
So I'll make that motion.
Second.
Thank you.
So you'll work with the applicant and come back to us with a report next week.
Yes, sir.
The next speaker is Zareh Vartanian. My apologies if I mangled your name, and this would be on page 52 of our packets.
Good morning.
And you'll have 2 minutes.
Okay. I own 3 lots in the city of Tahanga, and one of the lots did not comply according to the fire department.
Please speak right into the microphone.
And I'm sorry. And the reason I'm here to show that the fire department was at the wrong place, and by the pictures they show me at the hearing. And I have copies here that I can provide you and just walk you through it real fast and show you that they were at the wrong place.
Sir, is this new information, or did you present this also at the hearing?
At the hearing, I tried to explain that I never had problem, and out of the 3 lots, only the one of the lots were did not pass the clearance, and I tried to explain, and I didn't have any evidence since I looked at their pictures, and it clicked me that they were at the wrong place.
But did you present these pictures at the
No,
hearing?
this is the pictures that I picked up from the city. This is the pictures they took.
Okay. So this was not on the record at the hearing?
It was on the hearing, and I just looked at them, and then I explained them, and I figured I was okay since they said no, they did not pass, and that's why I'm here to show you.
These photos were available at the time of the hearing and were presented.
And the fire department response to this?
This is a similar situation where there's a property line issue. The gentleman here believes that the property in question does not belong to him. And again, the fire department utilizes the same maps provided by the assessor's office with dimensions, and the inspector makes those calculations and determines who the property owner is. And he determined that this is the property owner. He was cited for violations. Photos are taken, and the property was put in a package and contracted out. Normally, again, once a property owner disagrees with our calculations, they must provide proof. Get an authorized licensed land surveyor to show us where we are in error. Until that is done, our calculations is what stands.
And initially at the city attorney hearing that's provided after they're found in noncompliance, these are when the issues are often raised if the opinion of the property owner is that it is not his property. Those issues are first dealt with at the city attorney hearing, where the fire department verifies the ownership of the property. And if there is evidence to be presented, the landowner often does it at that time. And if not, then at the time they are before the hearing officer, this is the purpose of the hearing, is for them to present all the information they have related to the ownership, and that information and issue was handled by the hearing officer at this time, and the hearing officer determined that based on the information before it, that the property was owned by the homeowner or the landowner and was properly assessed.
And this is my first time through this process, but it seems like, I'm not sure if I'd call it a flaw, but there's sort of an inherent difficulty in this, in that if it would cost a few $1,000s to get your land surveyed to prove it, and you're talking about, a relatively tiny brush clearance issue, it's almost never in the financial interest of the property owner to prove their case. It's not a cost-effective way to do it. Is there a better way to deal with this that we can think of? Or at least
Currently,
The fire department utilizes all the information before them and all the legal information that they are entitled to about the ownership of property. And in order to enforce brush clearance in the very high hazard fire zone, they need to enforce against what are deemed to be the lawful owners of the property. And we work in partnership with the county assessor's office to determine that.
And these are the same dimensions that he's actually paying taxes on?
Correct.
yes.
I have a question. The gentleman says that he's had the property for 7 years, had it cleaned. Did you present a bill showing that you had it cleaned this year to the same location you did in the previous years?
I could provide that, but I didn't show at the hearing, and
That's kind of important. You're saying you cleaned it. That's kind of important evidence to show that you did.
yes, because if you see, I have 3 lots. Out of the 3 lots, one of them was just a little bit of it needed more work, and when I talked to the inspector, he said, just needs more work. We went back, and we took care of it, and I thought that was the end of it, and boom, here I am with a heavy bill, and I'm lucky. I have a survey map here, which I did a few years ago, and it's a stamped survey map, and I can walk to you and show you exactly that people that did the brush clearance, doesn't belong to me.
Does your survey map conflict with the fire department?
Yes.
Okay, we got a yes and a no.
According to the hearing officer, who is the fact finder, it did not conflict, and as you've listened to the homeowner indicated that there was some issue about one of the properties not being fully in compliance, which is the reason why we are actually here. It was not in compliance by the deadline, and he did get assessed.
Okay, so the $450 clearance was just for a little portion of the property then?
That's correct.
It cost them $350 to the 3 lots.
That's not the issue. The question is, was it a little section you didn't do?
Supposedly, yeah.
Well,
Yeah.
supposedly is enough. That's
Yes.
admission of guilt, okay?
Yes.
You didn't finish the job. So
Right.
now we have to finish the job.
Yes, but
Okay.
if I can show you where they finished it, it's not
You know,
in
it's
my...
not a matter of whether it's 2 feet wide or 400 feet wide. The fact is, we had to come out and do it, and we have to pay that bill. That's the problem.
But if you're at the wrong place, you're doing somebody else's job.
Yeah, but that's, the city attorney's saying they looked at your stuff and they determined they are not at the wrong place.
I have pictures that was taken by them, and they can show you clearly they're not in the right place.
Was the other place cited? Was there any adjacent property cited?
I don't have the information here available to me on the other properties, but I can look that information up. Normally, that area has to be cleaned annually, so I'd have to review the record in the file to find out the other adjoining properties.
But it would appear that the property owner has 3 adjacent properties, and 2 3/4 of it was cleaned. And it's the quarter that was not is the subject of the hearing here today.
I move we sustain the staff recommendation.
I second.
Can we, as part of the process, have the fire department work with the applicant to make sure they know for the future exactly where their line is.
Councilman.
We asked to physically go and do that.
I'm Assistant Chief Craig Fry. I'm the acting fire marshal for the city of Los Angeles and in charge of the brush unit. One of the situations you bring up is we use the most current information available to us. The information provided to us is updated annually by the county assessors. This is the same information that you would use if you were selling your property. It would be the same one that you would be putting onto your legal documents if you were going to put that property up for sale, and if there was any legal issues that we're dealing with that. Our inspectors will go out. We do have the as current information as we can get with our GPS, if that's available, via the county assessors. For us to go out, we inspect over 120,000 parcels in the city of Los Angeles. To verify every single one of those parcels would be not only impossible with the time constraints we're dealing in, it would be fiscally irresponsible for us to do that. If a person has a problem with the county assessor's maps, which is the most current, that is something that we listen to through the process. As our city attorney has stated, they're given that opportunity at the city attorney's hearing to provide that information to us. The hearing officer is an independent individual that will look at the boundary maps that they have. And if you read the documentation, we offered to send our inspector back out with these people to help clarify any of that information. So we do, before it gets to this stage, we really do our due diligence to make sure that we are providing that service to the best of our ability. Believe me, it's something we do not want to be up here doing. It's something that is necessary for public safety.
But you can do this after the fact, have an inspector go out with the applicant so that this doesn't happen.
And if you read the documentation, that was provided to the individual.
Okay.
And even after that, the hearing officer decided that we were within city regulations to do this.
But for the future, he would now know where that line is according to the city.
Absolutely.
Okay. Thank you.
Let me just ask one clear. You said did he take you up on that offer?
That was provided to him. I do not know if he accepted it. If you read the hearing officer did it. Our inspectors are available. We have 13 inspectors that will be happy to go out and do that with them prior to getting here, so we don't have the same situation happen all the time. But we have them available. We make them available to them, and we will go to any response that comes in.
So did you understand you had that particular offer made to you, and did you take advantage of it?
Well, when I got the notice from the city, I did call the inspector.
When you were at the hearing, that they had inspectors that would go out?
At the hearing, I didn't know that I could have asked him to go back with me and show me the property lines. No, I didn't know that.
Yeah, the hearing officer states in his recommendations that they will be made available, and there was no request made.
It states in the record that we have also.
Okay, so if, do we need to have a roll call on that, or is it just presumed without,
Smith moved,
approved without objection?
Stay in the board recommendation.
Total assessment.
Okay. All right, that is sustained. Next item is, is that it?
What number?
Try again. I'll call again Jacqueline Cabrera. Okay, so has not appeared. And we have one speaker on the subject in general, Ms. Patricia Hurst.
Are we done with the hearings?
I can't help smiling about listening to this issue on the assessor's rules, the assessor information. 8 years ago, at the top of Mountain Gate, looking down Mandeville Canyon, there are thousands of acres that are owned by someone. So I went to the fire department with someone and said, here's the map, here's the acreage, tell me who owns it. Oh, we can't do that. I said, excuse me? I'm staying here and not moving till I find out. So after about 15 minutes, they pulled the file, and it was owned by Castle and Cook. So I said, I'd like to know where you're mailing the notices. We can't give you that. I mean, I never saw such a backup against trying to get something done. So now I'm staying there until finally they relinquish the information, and it turns out that the fire department had been mailing the notices to an address that no longer existed for years. So if they're getting their addresses from the assessor's office and the numbers aren't correct, maybe there should be some homework done about the assessor's office. It took a very unattractive scene with the fire department to get this information. I then called Mr. Murdoch, the owner of Castle and Cook, and said, where would you like your fire assessment or your fire notices sent to you? Where do you want them to go to? His office at that time was in L.A. It's now in Woodland Hills or Westlake Village. But it took an individual saying, I'm not going to put up with it. And, you know, as Mr. Parks has said, I feel like Queen of the Santa Monica Mountains. I am not. I just don't want to see fires that could be prevented. And if the assessor rolls are inaccurate, whether it's property line or mailing address, they need to be at the table too. Thank you.
Thank you. We'll also need a motion.
If I could, let me just, Captain, how many assessments we do a year on fires, fire brush clearance?
We conduct 132,000 brush inspections a year.
And of that, how many errors come back to us?
As far as mailing addresses?
Yeah.
That varies. We normally cite between 18 to 12,000 notices of noncompliance, and out of that amount is usually about 1,000 or so that we get to come back to us with bad addresses.
So less than 1% error.
Yes.
Thank you.
We'll need a motion, assuming Jacqueline Cabrera has not appeared, we'll need a motion to sustain that item as well.
Sustain the assessment, full value.
I'll second that. And without objection, that'll be sustained as well. And so if we close that public hearing?
To confirm, the committee is continuing the matter until 1 week, pending report backs from LAFD on 2 of the appeals presented today.
Yes, sir.
Thank you.
Correct.
I'd like to temporarily recess the regular Public Safety Committee meeting and start the special Public Safety Committee meeting.
Oh, he's got to change the page. Hold on.
The 2 report backs. It stays together in one packet. Now a little bit flips over. The 2 issues we have to report back. That's it. Just break.
Procurement process, policy, line item.
They were here at 8:30. Only one. There's also still here.
Well, you close the hearing.
Can we reopen it?
To reopen?
That's the committee. They were here. What's it?
Go get them.
Go get them.
I'll get them.
That's what I'm talking about.
We were having too much fun to let you go.
Okay. We're going to recess the special meeting and reopen the public hearing of our regular meeting. So we had a couple folks surface that we didn't have earlier.
I did already. Thank you, Council.
No, we're going back.
Yeah. Okay. Yeah. Change it again.
Okay.
I'll change it again after this.
Okay.
The page number. Okay, the speaker is George
What number?
George Papadakis. I mangled that name, and give us a minute to figure out where this is.
It's on page 173.
175?
173.
173. Thank you.
And you'll have 2 minutes.
73, 74, 75, and 7. 173, 74, and 75.
Okay, whenever you're ready.
Hi, my name is George Pakidis.
Page 173.
Yeah, he owns 3 lots, so his 3 assessment appeals are on page 173, 174, and 175.
Okay, now if you make your presentations.
Yes. A year ago, I was charged by the fire department for $4,000 of the violation of non-clearance on my lots, which I paid painfully. This year also, I got another charge from the fire department, close to $3,000. They claim that they sent me a notice to clean my properties again, which I never got them. And that's why I'm standing right now, that I paid $4,000 last year now.
Yes.
I have to pay another $3,000, claim that they sent me the notices, but I never got them. Never got any notice.
What's the story with the notices? What do we know about that?
There are 3 lots. The first one, that's on page 173, evidence was presented that showed that he actually purchased a property after the property was already cleared. And for that reason, the hearing officer weighed in his favor and waived his entire assessment. The other 2 properties, the other 2 lots, which are on page 174 and 175, Mr. Pakidis, excuse me if I'm pronouncing that incorrectly, had previously already owned these properties. We mailed again to the address that's on record with the assessor's office when we did our property search. He's claiming that he never received those notices. The information that we show that that is his accurate address. Again, we served the property owner 2 ways, by mailing and by posting the address. The notices went out, they were not returned back to the fire department as a bad address, and so the hearing officer weighed that he was properly served with the notices. And we posted the property.
What's the address of the property?
It's a vacant lot, and it's we show the mailing address there on Etowanda Avenue.
Pardon me?
The property that was in question is a vacant lot, but the mailing address we show here is on Etowanda Avenue.
Sir, do you live on Etowanda Avenue?
Yes, I do.
At 7357?
Correct.
Okay, and where's the vacant lot located? Or vacant lots?
I don't have the actual location of what street the vacant lot is, but it's a vacant land that's in the hillside area.
CB2, so it's the hillsides, it's in the Stung area, or where is it? Where's your lots?
The lots are Lower Canyon and near Sunset.
Lower Sunset.
Lower Canyon, Sunset.
If you had this problem last year, why didn't you take action this year so you wouldn't have trouble again?
Well, I missed that I forgot to go and clear the property again. But if the fire department sent the notice, if I got it, I'll probably clean it, because cost me less than $200 to...
But you had this
which
problem
I did
last
it
year.
this year.
I wouldn't, if I had trouble and it cost me that kind of money last year, I wouldn't let it happen again. So I wouldn't wait.
I missed it, my mistake.
It's only $250 to clear the property.
Right.
$250 to clear it, but the fee, the administrative fee, basically what it costs the city, the resources, et cetera, that's $1,026.
I know, but
That's
from
the problem.
last year, I learned my lesson on that, but
Yeah, it's not just the $250, it's the administrative that comes up. And then you got 3, so you get charged 3 times.
Move the assessment.
I second. Full assessment on all 3.
Any objections to that? If not, that assessment will go forward as...
Clarify, council members, I'm sorry, Mr. Koretz. There are 3 assessments, and the assessments move forward as stated in your book, or did you mention there was
He owns three lots.
Yes, sir.
1 out of the 3 was waived by the hearing officer.
So the assessment on page 173 was waived by the board?
That's correct.
That isn't indicated here in the book?
That's the only 2 that's being assessed,
So
yes.
there are 2 assessments, pages 174, 175 only, and what's printed here is incorrect, because it's already been waived.
No.
This is correct.
This is
What
correct.
the board, what
It says
the
to be
council
waived.
is affirming the decision made by the
Hearing
hearing officer, which would continue the waiver with property 1, and it would
Right.
assess property 2 and 3. So you would be
You
required
waived, got it.
to pay
Okay.
the assessment for the other 2 properties.
Thank you.
And that's what the motion is.
And please mark that on your calendar next year.
yes.
Okay?
So you're saving $1,276 by coming here today.
Thanks.
And I believe there's one more item. And thank you. Kwan Su Na. And I don't have a file number either.
I believe that's page 121.
Hello, my name is Kwang Suna. This is against for the charge of violation of bush clearance. Last September, I cleared my bush with the contractor. I paid him $700, but I got the fine from the fire department. But one thing I don't understand, I owned this property almost 20 years, but last 20 years I didn't have any problem with same spot, same way, same man, but last year I got fined. That's all.
Okay. The appellant came to the hearing and stated that he had done his job, done his work, and that he had a bill that he presented from his gardener that had done the work. According to the fire department record, the property was not in full compliance. There was work that had been done, but there was still partial work that still needed to be completed. That was indicated on his notice. As you can see, the notice was sent on September the 3rd, 2008. For notice of noncompliance, we got nothing in return back. He was sent a second notice of noncompliance and an invitation to come to a city attorney hearing on October the 6th of 2008, and we got no response. Then the property was subsequently, it was put into a contract, and it was posted on October the 23rd of 2008 and was cleared in November. So although the gentleman here, the appellant, did do some work, but the property still remained not in compliance, and the fire department took action by following its procedure, continuing to send them notices, and he was subsequently contracted and assessed.
And at the city attorney hearing, there were photographs available for the homeowner to view showing the condition of the property and explaining why it was not in compliance with the standards of the inspection.
And why was it not in compliance?
There was still too much brush and ground covering.
That remained on the property.
So he did a partial cleanup.
Correct.
That's correct. He did partial clearance.
Does it say how high the vegetation can be? Is there a standard that they subscribe to?
Oh, yes. Excuse me, yes. The notice does indicate how far to clear, 200 feet from your home, your grass cut down to 3 inches, your shrubs trimmed up 1/3 of their height, spaced 18 feet, so it's detailed.
And there's additional information on the website. There's a whole section on the Los Angeles Fire Department's website devoted to brush clearings.
And you've owned this property and been clearing it the same way for how long, did you say?
Last 4 years, the same contractor did the same job.
Any motion from anyone? What do we think?
Move the staff report.
Second.
You need to make sure your contractor does a better job when you get notice that it wasn't done good enough. Go back to him and tell him to finish it up right.
I think reliable. He did a good job every time.
He didn't do a job
Apparently not.
according to the specifics. That's the problem.
Okay, thank you, and that once again closes the public hearing. And we'll adjourn this meeting again, and
Then we mean it.
Once again go into a special meeting.
Are you sure?
We really mean it. this
We're
time.
pretty sure this time.
He's got tired of waiting.
When you think that we did 130,000,
As I always thought, I remember years ago, the same thing.
it's all up to you.
Yep. Same one. They have 12 of them, huh?
Okay, Dennis. The Dennis Zine Show. We got him in an LAPD.
If we could call this item.
Special meeting item number 1, or item number 7 on the supplemental page. City Controller, Emergency Management Department, Police Department, and Fire Department to present verbal reports on issues related to the procurement process for contract with catering firms, identification of the current contracts for such services, policy and criteria for providing meals to city staff at taxpayer expense for emergency incidents and planned events, and specifying the line item and the respective budgets of each department for the provision of meals for emergency incidents and planned events.
And if we could have representatives come up from the Emergency Management Department, General Services Department, LAPD, and Fire Department, and the Controller's Office, if we have a representative. And whoever would like to start, I'll leave it up to you all.
Good morning, Mr. Chair. Jim Featherstone, General Manager of the Emergency Management Department, members of the committee. This was an unanticipated, emotionally charged public event for which 750,000 persons were anticipated to be in attendance. More than 3,000 emergency responders and support personnel were deployed with the purpose of assisting the public, maintaining order, and preventing breaches of peace. By comparison, this would be similar to fielding 3 military battalions. In provisioning for this operation, the Emergency Management Department, EMD, was tasked with coordinating the efforts to make sure personnel had enough sustenance to keep them optimally functional should their length of deployment remain as planned or be extended due to unanticipated events. Roll call for the majority of responders that day was at 0300 hours in the morning of July 7th. Logistical support for this type of deployment is considerable. Procurement processes, quality, health and safety, and quantity are factors considered by the logistics planners. EMD acted pursuant to 3 criteria. 1, the only related city policy pertaining to feeding the personnel at issue. The meals should meet federal, state, and county specifications for emergency responders
and the city's vendors list would be provided for options for sources of meals which meet the emergency responder specifications. The city hosting policy actually authorizes the feeding of city employees. That's Controller's Memo 09-003. This policy was not a perfect fit for this event, but this event did not fit any defined circumstances we've previously encountered. However, the policy was pertinent in that it authorized the feeding of personnel during the deployment. We spent approximately $14 per person per day, substantially less than the maximum designated by this policy. The meals did meet federal, state, and county specifications for emergency responders. The United States Department of Agriculture sets forth specifications for specifically sack lunch content, packaging, and shelf life in the National Mobile Field Services contract. Per the USDA document, there's a minimum of what a sack lunch consists of. The state of California and the county of Los Angeles also adhere to these specifications when provisioning for emergency responder deployment. The city vendors list, the vendor used for this event is listed as a city vendor and meets the USDA specifications for this type of request. More importantly, the key task was provisioning from the closest, least expensive vendor who could and has in the past met the USDA specifications. For 3,500 meals on a compressed timeline, that was the challenge. In terms of cost specifications and timeline, the vendor used was qualified. As indicated earlier, the meals cost approximately $14 each. The source, Jensen's Finest Food, was a considerable distance away. One similarly qualified source was closer, but cost per meal would have been $16. They are not a city vendor. Thus, the total would have been $7,000 more had we used the closer vendor. On the afternoon of July 6th, between 1,300 and 1,400 hours, 3,500 meals were ordered from the vendor. By 2,200 hours that night, the first 2,000 meals were delivered to the staging area. By midnight, the balance of the order had been delivered. As responders arrived for roll call at 0300 hours, they received meals and water for the day. This precluded the planning cadre from having to develop and implement a feeding and watering rotation plan and its subsequent impact on operational capability. It also avoided the break-in service and readiness of more than 3,000 responders queuing up to eat in and around the operational area. In sum, an approved city vendor was used. The vendor met the safest product specifications. The vendor was able to produce the quantity and quality requested and met the delivery deadline. Our city hosts several large planned events each year and is always at risk for disasters, natural, man-made, and accidental. I'm committed to working with other city departments, the city council, and the mayor's office to explore more efficient and cost-effective ways to provide logistical support to ensure the safety and well-being of the public and our responders.
Why don't we hear all the presenters and then we can ask questions afterwards? Unless you're only here to answer questions, if any of you have additional comments.
No, that clarified it quite a bit. We worked in partnership. This event was a unified command between the fire and...
Your name, please?
Name is Captain Todd Chamberlain, CO of Emergency Operations Division. And as Mr. Featherstone stated, this was a unified command event that involved a lot of different city entities involved to make sure that this ran flawlessly and smoothly and provided for the safety of the people, both for the city of Los Angeles as well as for the people coming into this venue. And a lot of the stuff that he detailed was things that were thought about and discussed prior to the event occurring. And when you're dealing with something of that magnitude, of that size, of the potential that could impact this city, the ability to have the officers and the personnel from all city entities fed and watered for the duration of this event is extremely important so that we can provide the best service possible to the city.
You said this was an unplanned emergency. This seems like it's more in a category of its own, which would be a planned emergency, because we obviously knew it was happening, although it was on relatively short notice. What's the procurement process for selecting contractors to provide meals for city staff? And how many contractors does the city have that could provide meals, and where are they located?
My name is Don Frazier. I'm Assistant Chief in charge of the Supply and Maintenance Division with the Fire Department. And the Fire Department probably has the most experience performing what you just described, purchasing meals for staff to feed during an operational period. There are no city contracts that cover meals, but we have an assortment of vendors who have been declared as a city vendor, so they meet the purchasing requirements of the city that we tap for an event such as this. When we look to a vendor to provide meals, we look at the needs of the operation. And in this case here, this sack lunch that I brought a sample of was perfect for that bill, in that we didn't know how long this operational period would last. This meal provides us with 2 sandwiches, 2 drinks, 2 pieces of fruit, and so forth, so that the individual officer or member can actually use it for more than one meal. And that way we don't have to provide the transportation logistics or the rest periods that would be required to provide some kind of other feeding method. So in short, this is the largest feeding that we've done in my 12 years involved with the supply. Many of our feeds come as a result of an emergency, and so it's very spontaneous. The call for meals came to us literally 12 hours before required deployment. So, and that was factored in selecting the vendor that we did.
So am I safe in assuming that there are no appropriate vendors that were both closer and could do the meal at a lower price?
The appropriate vendors, there are other vendors, and we contacted 2 other vendors prior to selecting Jensen's to see if they could deliver. And so, no, there were no other vendors that were available to us at the time.
So of all the appropriate vendors, particularly in the city of Los Angeles, there were only 2 others that could have been considered, and they weren't able to do it.
That's correct, sir.
That strikes me as a pretty small list of vendors. How do we have so few options?
Ken Desowitz, representing General Services. The city does have contracts for food, but they're in very specialized circumstances. We have contract for the jail meals with a company called Langolay. They're located in Laguna Beach. That's a fairly new contract. We used to have a company that did that, was called DeBilio, located in Anaheim. We have a contract for kosher meals for Department of Aging and Rec and Parks with the Jewish Family Associates. They're located in Los Angeles. And we have a contract for senior meals, also for Rec and Parks and Aging, with a company called Morrison Management Specialists, located in North Hills. The feeding policy really specifies that the use of procurement cards for flexibility, maximum flexibility in cases of emergencies. And that flexibility is needed because the meals need to be provided from various locations throughout the area. In this case, it was determined that Jensen's was the most appropriate.
Mr. Chair, actually, in looking at the USDA list of contractors, there's a vendor in Downey and a vendor in El Segundo. Both of them were almost $3 more expensive, and they aren't on the city vendor list.
So does the city have a process whereby they would look for reasonable vendors, or how do we go about having such a short list and so few people available? Or are there requirements that some folks can't meet? Because as it was suggested, one would think you could go to a few franchises that specialize in this kind of thing and get it done more cheaply.
We have an emergency operations manual that is used by the logistics section, and in that manual there are locations of suppliers for food and other supplies that are used on an emergency basis. I don't know if that list was used in this circumstance.
We've been working through, since February of '08, we've been developing the Citywide Emergency Logistics Plan. It actually was approved in September of '08. The Emergency Operations Board approved it. There are a lot of details that still need to be worked out, but prior to September 15th, '08, we didn't have a Citywide Emergency Logistics Plan. So we've come up with that. We still need to work out a lot of the details. What's key in this, and I think, sir, in this discussion is the definition of what type of event we had. This was not a large planned event such as the Oscars or the Emmys or something like that. And this wasn't an emergency, declared or non-declared. This is a very asymmetrical event. And so how we responded to it, even though we responded, like I said earlier, with essentially 3 military battalions worth of responders, we still weren't in that, we were in an emergent situation, but it wasn't truly an emergency.
I wonder if we'd get the Controller's Office's take on this.
Thank you. Claire Bartels, now with the Controller's Office. Thank you for having us here today. I'm sure you're all aware the Controller's Office's participation in the procurement process is generally at the tail end. That is, we approve the requests for authority to expend funds and verify that the funds are available. Not at the upfront phase. The Controller's Office, however, as stated by Mr. Featherstone, has developed some policies relative to the procurement of food, none of which pertain to this situation. One, the hosting of events is in particular not for events that you're feeding only city employees, but rather non-city employees and at meetings. And the other one is for departmental functions or departmental meetings and retreats. So it's true, there is no policy for, and I should add that, of course, there is citywide policy for emergencies that has been detailed here today, but the point of Controller Gruhl's letter last Monday was that this does not fit the description of an emergency in the catastrophic earthquake, fire, flood type sense, nor does it fit the planned event as just described. We're offering our services, the Controller's Office, in creating a policy. And in fact, we've been advising recently that one of the proprietary departments in distinguishing for procurement purposes between an emergency procurement and an urgent procurement. Perhaps that's one way to describe this. But clearly there is a void in policy, and the city needs to have this in-between type of policy. So we offer our assistance and support completely with the department's position on needing alternatives, because they did follow the rules as they are, but the rules don't seem to fit the situation. Thank you.
Yeah, this seems almost more of a rush than an emergency. And I don't know how much that would change how we approach this. It's kind of a surprise that we have so few options that are reasonable and in the city of Los Angeles, and I don't know whether that has anything to do with the fact that we may not have looked that hard in the process, in pre-planning what we do in these emergencies, what our choices are. I don't know if there are ways to look at more contractors and look at more vendors to see if there are folks that would be more appropriate in terms of cost and location.
Definitely. The location it's hard for any of us to imagine in a city as large as we are, the majority of our businesses being small and medium-sized, that there wouldn't be some willing vendors to be on the list for the future. But I don't think we've anticipated it. I don't think this is a common occurrence, that we're good at responding to real, true blue emergencies, and for better or for worse in the city of LA in the past couple decades, but not these types of in-between non-emergency emergencies.
Well, it may be even in an emergency, we should do a better job of looking at who our vendor choices would be and the costs before the emergency happens. I'm not sure that the issue of location and cost would have been that different if it was a true emergency, because we shouldn't have to scramble to find a choice that's more appropriate. We should have them hopefully at our fingertips. Now, which funds did the money come from? We
use money from the Emergency Operations Fund, which is controlled by EMD.
Okay. And I don't know if that's an appropriate source for those funds for a non-emergency emergency or not. But
Well, excuse me, the Controller's Office would verify, did verify, and does verify when that fund is being requested to be utilized, that an emergency was declared and that the funds are encumbered and available for that purpose. So both of those answers were yes, and so it was an appropriate expenditure given the city's current rules.
Okay. Any other questions?
Who declared the emergency?
The declaration of emergency isn't necessary to expend money from the Emergency Operations Fund.
Was there ever an emergency declared?
No, sir.
You said unanticipated event.
Yes, sir.
I don't see this as unanticipated at all. We were notified Thursday afternoon that the memorial service for Mr. Jackson would be the following Tuesday at 10 a.m. That left the rest of the day, Thursday, Friday, Saturday, Sunday, and then Monday to prepare. Were there preparations in the meantime for the procurement from the fire department, as you stated, 12 hours, you received a call 12 hours before Tuesday at 10 a.m.? What happened Friday, Saturday, Sunday, and the rest of the day Thursday for the procurement?
Friday, Saturday, and Sunday, the city business was shut down for the 3-day Independence Day weekend. But the planning process continued, and as the operational plan was being developed, the numbers and everything else that goes into the logistics planning was still being developed also. So
on Friday, Saturday, and Sunday?
Yes, sir.
And who was doing that?
The Unified Planning Cadre.
And they were on overtime doing that?
Some were and some weren't, to be honest with you. A lot of us worked through the weekend on it.
Worked on overtime or worked
no.
on?
Just switched the days,
regular,
moved days around, did what we had to do to make this thing come together.
But you normally would have had the day off?
Yes.
Okay. So I'm still trying to figure out, with the procurement process, who gave the green light? In my days of LAPD, we worked many long details, and we would go get food and come back. It was seldom that we'd get food provided by the city. Whether it's the Academy Awards or some other large event, we would somehow either eat before, after roll call, or sometime during. So what puzzles me is the procurement process on this to order 3,500 food sacks for the personnel, and how this whole mechanism took off. The purchase price, whatever that be, $14 or $16 or $13 or $10, I understand the Los Angeles Police Protective League put in $15,000 toward that.
Yes, sir.
Did any other agencies or any other departments or anything else like UFLAC put in money?
Not at this time.
So why did we go to the Police Protective League to get $15,000 when we have money for this type of purpose? Why would we go to a police union to pay for food for personnel when there's an emergency, or shall we say a procurement process out of the Controller's Office who authorizes money? Why would we go to a police union to get $15,000?
That was after the fact, council member. I had already given the go-ahead to order the lunches and pay for it out of the Emergency Operations Fund.
Because there was money in there.
Yes, sir.
So I can't understand why we go to the police union, not to say they weren't courageous to stand forward and represent their members, but if the city's paying for it, why do we then go tap into their funds?
Actually, we were looking at other options available. It was almost simultaneous if the two happened. The contact of the Police Protective League went out almost simultaneously as we were looking for funds, and it was bought off fairly quickly by the Protective League to go ahead and put some money up for that based upon the number of officers that were involved and the number of people who were involved in the Protective League.
Which was great for them to do that.
Yeah, it was wonderful.
Represent their members. But the necessity would be placed on the city, not the Protective League, which obviously was a city requirement and responsibility. When it comes to Laguna Beach and Anaheim, why would we contract with vendors for procurement outside the city of Los Angeles when we have so many businesses that are struggling, when we want to use that sales tax for the people in the city of Los Angeles? Why would we contract with Laguna Beach and Anaheim? Why can't we get vendors in this massive city of Los Angeles? It absolutely boggles the mind.
Those vendors won those bids on
lowest bid basis, public bid. And the competing businesses that put in bids were higher than the bids from Laguna Beach and Anaheim.
That's correct.
Okay, how do we market when we're doing the bid process? How do we put the word out to all these vendors for whatever they're supplying that the City of Los Angeles is obtaining information and RFPs, et cetera, for this process?
There's very detailed specifications and requirements that are established because especially the jail food and lunch programs that are administered by Rec and Parks and Aging. Rec and Parks and Aging programs are grant funded, I believe, by the state, and there are very stringent requirements on nutrition. Those bids are publicly advertised. They are sent to a list of recommended companies that fulfill or meet those requirements on the ability to produce meals of those nutritional values. Those bids are also posted on the website, on the BAVN website. We do all we can to reach out and attract competition, but the bottom line is the vendor that submits the lowest bid that meets the specification wins the contract.
Well, it seems like maybe we need to improve our marketing to the businesses in Los Angeles to let them know of these opportunities, that they would be able to meet the criteria. It's nice that we use someone in North Hills and someone in Los Angeles, but it puzzles me we're going to go to Laguna Beach or Anaheim when we have so many food distribution facilities in the City of Los Angeles that must meet the standard. What about the relief? When we talk about this aspect, I guess it was anticipated officers would be locked down to a location for an extended period of time. What about relief for the officers?
Yeah, that's
Restroom relief or any other kind of relief?
That's one of the reasons why this became so necessary, to make sure that these officers were fed throughout the duration of this event, because as Mr. Featherstone stated, this was an event that involved a lot of different operational periods, and based upon the severity of it, it could have kept going on. Obviously, that did not materialize, so we were able to shut it down earlier. But as far as the relief, you were talking earlier about planning and why didn't we order things earlier and things like that. A lot of it is just as the planning mechanism took effect and as we became known of how big area was going to be locked down and how many resources were going to be within that area and have to be in fixed post, and not the ability to drive around freely in that area and go by McDonald's or go by Subway or go by any other vendor, how necessary it was to make sure that they had food to keep them up and going, because you're looking at possibly a 15-hour period that someone's going to have to stand on a post. As far as relief for restrooms and comfort and things like that, that was worked into it through the supervisors on scene. There was porta potties that were delivered on scene. There was additional items like that. But the food and the water were handed out at the very beginning, and they were advised from the very beginning to utilize this substance throughout the duration of their time on the venue, and that's how it worked.
Yeah, I don't fault the police department in deploying as they deployed based upon the projections.
That's correct.
Who came up with this 750,000 people invading Los Angeles? 750,000 is an incredible number of people. Whoever came up with that number to converge on the Staples Nokia location, which got all the alarms sounded, which got everybody concerned, how are we going to accommodate these folks? Who came up with the number? Where did that generate from? Which obviously created everything that we're talking about to occur.
And Mr. Feather, I don't know if you have any more detailed information, but really when you look at the media blast that occurred and what happened, it is like nothing that's ever been seen, I think, by this city. And then when you look at the fact that it's still 2 weeks, almost 3 weeks after Mr. Jackson's death, and every channel you turn on, every news you go to, you still see tidbits and descriptions of the funeral process and the event. I think you can kind of understand where that information came from, the outpouring of people who are affiliated with Mr. Jackson, the community, the citizens. The amount of time that was spent covering this event, the projection was based upon what was looked at, how much news coverage, how much media, how much chatter was going on in different places. What has been historically in the past with other icons of music or other people at that level, celebrities or politicians or other events, and then do our best we can to ensure that this event goes off for the public safety of the City of Los Angeles.
One of the benchmarks we looked at was the recent Lakers celebration, and we looked at the number of people there for a local issue. We were briefed, I forget which day it was in the planning process. They were saying that the website for the tickets was getting 220,000 hits per second. So that and the intel function for this event was looking at things like Twitter and the other social networking, because literally now crowds or groups of people can move at the speed of light with electronics. So I think that the effort here was to prepare for the, I won't say worst case, but for the largest case that may have happened.
And that was all generated by the folks that are generating the tickets, and that was AEG Staples?
That particular...
the ticket distribution to attend the memorial service.
They gave us the quote of 220 hits per second.
So that was generated by them. The number came from them.
Yes.
So basically, numbers were generated in the media. Numbers were generated that the anticipated crowd would be larger than our normal capacity for an event, which got all these wheels into action.
It's like any event, you're going to look at all the sources available to you to try to come up with the best conclusion or the best thought process that you can to deploy resources in a manner that could effectively address the situation.
And in the end result, how many without a ticket showed up at the Nokia Staples?
I think I got somewhere in the area, I think it was less than 5 or near
Yeah.
10. And again, I think a lot of that went in, it wasn't a failure that large crowds didn't show up. That was a success, and that was a success based on a lot of really good pre-planning on the event. And it was based on the success of not just working strictly with fire or working strictly with the police or DOT, but it was working with the media and letting everyone out there know that unless you have a ticket to attend this event, there's no chance of getting in. Now, of course, that's something, you hope happens where people will listen to it and adhere to it, but there's always that possibility, and from what we were getting from the sense of the media and the tweeters and the Twitters or whatever it is, there was a high volume of interest in this event, and we wanted to ensure as a city that we were prepared to safely have this event run smoothly, run safely for everyone involved, and then conclude it.
One of the early objectives, council member, it's very obvious that there was an operational or traditional objective in terms of force deployment, et cetera. But one of the primary objectives early on and throughout the incident was what we call crisis messaging. So we tried to get ahead of the curve in terms of getting the message out, stay away if you don't have a ticket, and not in an unfriendly manner, but to cause the public to understand why it wouldn't be a good thing to converge on the Staples complex. So essentially the crisis messaging was probably the most successful component of the operation.
So the approval to purchase the food was by your office?
Yes, sir.
And the controller approved that with the understanding it would cost $14 at first?
That funds were available for that purpose and that they were within the guidelines for paying. By that point, as stated, the food had been ordered and needed to be delivered apparently in time for the 3 o'clock deployment of the personnel. So
somehow we need to look at our vendor list and the opportunity to make sure that we have provisions for our emergency personnel, other city personnel, that they're covered. But maybe we need to look deeper into the city of Los Angeles for many of the businesses that could provide food that meet the FDA standard at a reasonable price, closer proximity. Because if you look at the nearly $50,000 bill, $15,000 offset by the Police Protective League, those are dollars that are going to another county,
yes, sir,
another community, and as we struggle with a budget deficit and struggle to try and make ends meet here in Los Angeles, and furloughs for a lot of city employees, and no pay raises, et cetera, we would assume that we'd like to put those dollars back in our local economy. So somehow, this whole process, and it's not only the food vending, it's where we got the restrooms from, because there were hundreds of those ordered, I understand. Everything that takes place, if we can contain it within our jurisdiction. We didn't call on the sheriffs to hire patrol, even though the hire patrol was on the motorcade, but we were taking care of our people. LAPD, fire department, general services, and the whole list of folks. But we need to somehow, with this procurement process, figure out with the assistance of the Comptroller's Office, how we can do this out within the boundaries of Los Angeles, not outside our boundaries, for everyone's benefit, at a reasonable cost, meets the FDA standard, meets our criteria, so we can keep our businesses at least moving forward and not shutting their doors and laying off more people in Los Angeles. That's my big issue with the procurement process. The other concerns I know we're going to be discussing in council the next Tuesday, which involves a lot of other issues. But I don't, again, fault the police department for what they needed to do, or emergency management what they needed to do. Now the questions are generated, why do we do this and why do that, and how much did it cost, and how do we change it for the future? I've been to the fires, I've been to the other earthquakes where obviously those are emergency situations. You need to get your people in and you don't know when they're going to go home. We understand that. This situation, a lot of people looking at, it was a week after the tragic death of Michael Jackson that the decision was made to have the venue at Staples. And then from that day forward, this whole thing went into what we saw happen. And now it's the analysis to say how do we correct it for the next situation that takes place.
So why don't we ask the Controller's Office to work with all the entities that would be involved, LAPD, Fire, CLA, and CAO's office to come up with a policy for how to deal with these kinds of situations in the future.
We'd be pleased to.
Okay.
Thank you.
And the Office of Emergency Management also.
I hope that sandwich isn't from the flash.
Is that still edible?
What's the shelf life?
Actually, I'm getting kind of hungry. Maybe I can.
Okay, sorry, I didn't, I didn't
Beyond shelf life?
roll in since getting here. But we did have the opportunity to get the day of the visit, yes.
And with that, we are adjourned.
This 7 standard pounds to provide a balanced life versus
Pleasure. Thank you. Thank you.
What about your son? What do you need your son? What kind of American
Well, yeah, and that's why I'm asking.
I'm sure there's plenty of issues that cross the freeways.